the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, and please be seated. Okay, we'll begin with Lewis versus Circle K, and Mr. Lee.
Yes, Your Honor.
Come right on up.
May it please the court. Good morning. My name is Brian Lee. I represent Jonathan Lewis here on appeal. This appeal is from a summary judgment that was entered by the district court in this case, and we believe that the summary judgment was entered erroneously for different reasons, as well as we have brought other parts of the district court's rulings to other ones as well in this appeal for the court's consideration. The summary judgment, we believe, was erroneously entered because the district court committed error in finding that Circle K, the condition in front of the Circle K was an open and obvious hazard. We've briefed and we've shown that Circle K had the duty to warn invitees such as Mr. Lewis of dangerous conditions that it created. And it is undisputed in this case that they created the condition that Mr. Lewis slipped on. And so because of that, and because that this was completed at the entrance of the store, where customers such as Mr. Lewis would be going back and forth doing their normal business at the Circle K, we also believe that it was not open and obvious.
How busy was the traffic in front of the store? Do you have any evidence of that? I know they say that there were 7 people that came, but in terms of what the company could anticipate, what was the traffic at the store at this particular point?
Sure, Your Honor. I believe from the video itself, the time between when Mr. Lewis, I think, was just getting there into the parking lot, as well as when he's going into the store and then coming back during this time of cleaning, I believe there was at least 6 people, could be 7, depending upon the angles you're looking at, that would have been in and out of the store during this time.
Does that make a difference legally?
I don't believe so, Your Honor. And the reason is because...
I mean, if it doesn't make a difference, whether there's maybe he's the only person going in as opposed to whether there's a good deal of foot traffic, you don't think that makes a difference?
Well, I do caveat that, Judge. I do believe it does make a difference in the sense of this was an area of the store, obviously the entrance of the store that Circle K knew customers would be frequently coming in and out. So this is not a situation where this is a parking lot that's off-site and there wouldn't be any really recognition of foot traffic that would be there.
But it might make a difference in terms of what the store could anticipate by way of a distraction or what have you.
Sure, Judge, I do see what you're saying. Obviously, if there's a lot of people coming in and out of the store and they're, sort of a bustle, then you certainly, I think that would inure to the benefit, frankly.
If somebody's coming out of the store with a bag, or somebody's coming out of a store with a baby in a carriage or in a thing, or somebody's going in behind you or whatever, that could make a difference, could it not, in terms of the sort of distraction that the store could anticipate?
Sure, yes, sure, and it certainly would. That is a reasonable thing that a store has to guard against, because not everyone's going to be, I think, as you're going, Your Honor, not everyone's going to be looking at the ground, watching as they go into a store.
Not everybody's going to be the lone customer.
Very, very true, Judge. I do think that although that is certainly a flavor of the facts of a case where it could make it even more unlikely that someone may have seen what was going on, I think at the end of the day, the fact is that the condition itself, irregardless of who would have been and how many people would have been coming in at the one moment, the condition itself was not an open and obvious condition. The condition was not just that the concrete was wet, which could happen because of rain or a lot of different things. The condition that we're talking about in this case, what made it a dangerous condition is the fact that there was, the employee put the water, but also this chemical element, the CAF element that we're talking about.
What is the evidence in the record that the CAF increases sort of the slipperiness rather than decreases the slipperiness?
Yes, Your Honor. So Dr. Durig, who's our expert, he said, and this is at the Joint Appendix 346, he says that the CAF material is not meant to be used in a situation where there's a paint stripe or something that has basically taken up the pores of the concrete. It's used to pick up oil stains and things of that sort, because what it does is it basically kind of eats it. What he says, it eats the hydrocarbons, for a technical term. But what he does say is that in this particular case, that the CAF material would have laid on top of the painted stripe because it could not go down into the pores of the concrete. And so what we have in this case is we've got not only...
Yes. I got all that.
Yes.
But why do I think that makes it more rather than less slippery? Right? I mean, sand also would lay on top, but sometimes sand increases grit, sometimes it decreases it.
Sure.
So based on the record, what am I looking at to understand that the CAF made it more slippery than just water?
Because Dr. Durig in his testimony says that it laid on top of it, and therefore it was present on it. Now, but
does he then say, and that makes it more slippery? That's the part I'm missing, right?
Sure.
So I get the factual foundation, but what I don't naturally see is him saying CAF on paint is more slippery than water on paint.
Sure, and I think that the part of the reason why he is not able to go all the way there, Your Honor, is because he was not able to determine the slipperiness of the paint that was underneath. Because he does say that there are two elements of this. There's a paint that's underneath, and the paint could be just a flat paint. It could be something that has degraded over time, and therefore some of the concrete started to make it more rough. And then you put an element on top of it. Now, he does say that element was on top of it, but he was not able to determine the paint, and I guess you can call it the slipperiness of the paint that's under it as well, because that was spoliated. That's another part of our case.
It seems to me that my colleague raises a good question, and the question is what was the substance, and did the substance, whatever it might be, make the condition more or less, made the situation more or less dangerous? Is that a matter for the jury, the question of whether or not the substance as it was employed increased the danger or not? Is that part of what the jury would want to determine?
I do think that the jury would determine that, because it's something where the expert would talk about, because we know that the substance was there, we know the material was there, we know that Mr. Lewis slipped on the material. There's multiple pieces of evidence so that he slipped, and that there was what Dr. Durig talks about, a 10 to 12 inches across the painted line, which showed the material, meaning that we know he slipped on that material that was there, that was laid on top. We know that material was put on that painted stripe by the defendant, by Circle K's employee. And so when we get to the point of whether it was negligent to do that, The way that they were trying to, whatever they were doing with those materials.
But all I'm saying is the question of the exact properties of the material. And the enhanced or diminished degree of danger. Is that one of those things that's sufficiently in dispute that you'd want the jury to take a look at it?
I do believe, I don't believe that the properties of the CAF material are in dispute. Everybody knows what it was. Dr. Durr talks about it. Mr. Wiggins doesn't really dispute it, what the properties are. Whether that was a dangerous condition, meaning whether it was something that caused the slip, should not have been put on there, should have been put on there. Those are the issues that I think the jury is going to have to determine.
Can you help me? I just want to make sure I understand the precise grounds of the district court's decision. Now, I know the district court rejected some Daubert arguments that you made, but I'm talking about the district court's decision to enter summary judgment against you.
Yes, Your Honor.
One, the district court said that the dangerous condition was open and obvious.
That's right.
And in the alternative, the district court said you couldn't establish causation without expert testimony.
Correct. And I would add, Your Honor, that not only did it say that it wasn't an open and obvious condition, but the court also found that Circle K would not have anticipated the harm that it would cause to Mr. Lewis. I didn't want to.
No, I understand. Thank you.
Sorry
I appreciate the clarification. And the cause, as I will just say, I'm deeply confused by the district court's causation holding. The causation is that we can't prove that it was the slip and fall that ruptured the patella without expert testimony. That's what I read the district court as saying?
That's what I read it as well.
And you understand that as going to the causation of the injury, as in the ruptured patella, not the causation of causing him to fall down.
Correct.
Okay.
Yes, and as to the causation that you're talking about, Your Honor, what the district court found was that take it away from me, family. We've already talked about that. The evidence was, I think, really undisputed that Mr. Lewis said that he slipped. He said after he slipped, he tried to, I think, kind of plant on the ball of his foot to not fall down. And at the point where he does that, he feels like, I think he said he hears a pop. And Dr. Evans, the medical expert, says that his patellar tendon rupture was an acute event. That the hearing a pop after that sort of acute event is normal. And so when we're talking about the causation of the event, that is something that was not only from the evidence, from the lay testimony, not just from Mr. Lewis, but also from the expert testimony. This was an acute event, not some chronic event. I see that I'm in my time, Your Honor, so I will.
Yellow light means you got 2 minutes of your time.
Oh, 2 minutes of my original.
We'll give you a red light when your time to sit down.
Gotcha. Okay, I'm always.
You can always choose to sit down. We don't ever complain when people do, but.
I don't judge. Right, so I hope I've answered that correctly. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you.
All right, let's hear from you, Mr. Holt.
Thank you, Your Honor. May it please the court. Ryan Holt on behalf of the appellee, Circle K. We ask the court to affirm the district court's grant of summary judgment. In doing so, the court need not address the other questions of spoliation and expert exclusion. Should the court do so, we ask the court to affirm the district court in those regards as well. With respect to summary judgment.
Hold on. I don't think we can affirm without addressing spoliation, right? Because they claimed they should get spoliation sanctions, and they didn't get spoliation sanctions, but maybe if they'd gotten spoliation sanctions, they wouldn't have lost summary judgment. I don't know how we can avoid the spoliation question.
I think on the issue of medical causation, it certainly could be done. The issue of that essential element could be dealt with because that does not implicate the idea of the slipperiness. With the open and obvious.
Wait, whoa. The spoliation doesn't implicate the, what doesn't implicate the slipperiness?
So with respect to the medical causation basis for summary judgment, I don't believe that it would implicate the question of whether the condition of the pavement was such that it would have caused it in terms of duty and breach. I think the medical causation piece can still survive that. With respect to the open and obvious, of course, the basis of open and obvious is that there is a dangerous condition. It was simply that it was open and obvious.
How in the world is that true? Okay, I mean, as a just common social experience, I frequently walk on sidewalks that are obviously wet because it's recently rained or because something's dripped on them. It never once occurs to me, and I don't think it occurs to any reasonable person, that just because the pavement has a little water on it, that it's dangerous. In fact, sidewalks are designed not to be dangerous just because there's a little water on them. And so how is it open and obvious that it's been treated with a chemical that, according to the plaintiff, makes it way more slippery than normal slightly wet pavement? It just feels like the district court got this completely wrong to me.
I think it's helpful that it was not a rainy day. So first off, we're seeing liquid.
Fine, then they hosed it down with some water. They dumped, like, there's lots of ways that pavement gets wet that doesn't make it dangerously slippery.
Well, and I would certainly agree with that, Your Honor, but also with respect to the employee being there with a mop, being in that area.
Yeah, someone spilled a Diet Coke or something.
I think what's important is the Meadows case indicates that there has to be a reasonable inspection of some kind by the individual who's claiming that it was not
Do you think that that a plaintiff or anybody walking in and out could see the CAF? They could see it's wet, I got that. But do you really think that the CAF was open and obvious? Is that the argument that you're making, that a reasonable person walking in that store would be like, looks like a little bit of tiny grit on top of the paint, and that's probably an industrial cleaner that makes it slippery? Is that what was open and obvious?
No, Your Honor, not the substance itself, but the fact that somebody was putting something other than just water onto the surface.
This is somebody who should have put a sign there saying, "Don't walk here," and didn't.
Well,
Can I just go back real quick?
Yeah, of course.
You said other than water? Like, why was the person walking in supposed to know it was something other than water? Right? I mean, I've cleaned my driveway before. I've never done it with anything other than water. Admittedly, I don't run a gas station. But why would a person look at somebody that's, cleaning the pavement and think immediately, oh, I'll bet they're putting some chemicals out here?
I think what's helpful in this case is the individual with the mop who is in the process of doing some type of extra cleaning effort with that mop as opposed to just using a hose. And what the plaintiff indicated is that he could see that everything was very visible to him, he just was not paying attention to it. Of course.
But again, am I right that this person was supposed to have put up a sign saying no one do that? Like how when, say, someone's cleaning a slippery floor, they put up a sign that says, "This is slippery, don't, be careful."
My understanding is the sign would just indicate that it was wet, that there was something going on
Right,
there.
and that sign indicates this isn't just like normal wet, this is dangerously slippery wet, and maybe you should stay away from this. Like that sort of sign that is what is designed to tell people that?
It could help, but this individual also knew and admitted that it was readily apparent what was there. So it would be essentially
Readily
warning
apparent but you're committing the same mistake the district court did. Readily apparent that it was wet, yes, not readily apparent that it's way more slippery than a wet surface normally is.
And that's where we just turn back to the individual and what he had on his person and what he was in the act of doing, and that it wasn't simply hosing something down or
Okay,
rain.
so can I take you to Meadows?
Yes.
is honestly confusing to me why you think that Meadows is good for you, because Meadows seems terrible to you for me, because Meadows is a case in which the court said the plaintiff could have taken other non-obviously hazardous routes, one of which was a sidewalk. How is it good for you to rely on a case that the court says, even when it's raining, you can probably assume that it's not dangerous, obviously, to take a sidewalk?
I think in this case, there were those readily available routes that could be taken. And so that's why we rely on Meadows, is because...
But Meadows is literally a case that says, it seems to me, it's not obviously dangerous to take a sidewalk when it's wet.
Meadows seems to suggest that the wetness is something that ought to be avoided. And that
No, Meadows says don't go through like the median or something. You should do a reasonable thing, like take the sidewalk when it's raining.
Right, as opposed to the wet grass, which ended up having a kind of a more concealed condition.
Sort of like having a chemical that you don't know is there.
But for the fact that the individual who is applying it has the tools and what have you to indicate something else is going on.
It seemed that you would have to do so little to make the danger open and obvious. All you'd have to do is put some sort of signage up that said dangerous or slippery or whatever, but there was no signage here, and there were no cones here, and all the rest, and just a few simple steps would have made the danger open and obvious. But without those steps, it's as Judge Hyten said, the fact that is wet doesn't make it dangerous or slippery, and you need a signage, you need some signage or cones to convey that message, don't you?
That certainly would add to it, but again, we turn to the fact that the individual who's there and who's doing something is also indicative that there is something other than just wetness going on here at this point. Of course, another basis for summary judgment is the medical causation testimony.
So can I take you to that, which
Yes.
I also find deeply perplexing? I don't understand why all of your arguments don't go to damages rather than causation. So if I understand the argument is he can't show that the reason the patella ruptured, without medical evidence, that the reason the patella ruptured was because of the slippery surface rather than some defect in his, but I'm looking at his complaint. It does not say I am seeking damages only for a ruptured patella. It says I slipped and I sustained some injuries. And so this all seems like it goes to damages, not causation. Even assuming everything you say is right, I don't understand why this is causation.
Except for the fact that the injury Your Honor alludes to is the patellar tendon
I'm
rupture.
looking at his complaint. That is not the only injury alluded to in his complaint. I mean, if you slip and fall, you could get bruises, you could get cuts, you could get pain. Like, it's not just, like, it's not the only, I mean, I don't mean to minimize in any way the significance of rupturing one's patella, but that's not the only injury one can get when one falls down as a result of a negligent surface.
That seems to be the one in discovery that he indicated is the center of his damages.
It doesn't matter if it's the center of his damages. For causation purposes, it would have to be that he has suffered no legally cognizable harm whatsoever unless he can show this. And I don't know how you can establish that.
He does not state that legally cognizable harm separate from the patellar rupture. And the patellar rupture, the question is, does it happen as a result of a slip or as a result of some other mechanism? And all the expert testimony in this case is aligned to what we submit as the one reasonable inference, that it had to be either a foot plant or a toe catch, which would be due, of course, to Mr. Lewis, as opposed to some negligence on behalf of the location.
So even on its own terms, that doesn't seem to make sense to me, because the plaintiff here testified that he slipped and therefore attempted to use his toe to catch the fall, and then heard a pop, right? So his testimony, which we have to accept, is that in the process of slipping, he didn't slip like in a cartoon, right, where your foot goes out from under you and you fall on your back, right? Like, it turns out it wasn't a cartoon slip, but instead he slipped, and as lots of us have done, then tried to catch himself. He says, under oath, that in doing so, he tried to use his toe to do so, and when his toe hit the ground, he heard a pop. Right? It seems like to me the evidence is actually exactly what you've just said is at issue. That, like, it could have happened by virtue of his toe and knee moving in different directions effectively, right? That's what he alleged happens. Like, I don't know what I'm supposed to do. Your argument seems to be that the plaintiff's theory is how a tendon would rupture. And apart from Judge Hyten's point, like, I don't understand how your point doesn't simply actually support causation given his testimony.
There is expert testimony that suggests that a spontaneous rupture is very much something that occurred.
Oh, no. There is testimony. This is summary judgment. You can argue this to a jury, but there's testimony that it was not a spontaneous rupture. Right? We have such testimony, which means contrary testimony, right, simply doesn't matter, right? We throw it away for summary judgment. You might be able to convince a jury of this. You probably won't, but you might be able to, right? That it just like spontaneous combustion happened and it just blew up. But that's a theory at best you get to make to a jury. We have testimony that it was not, it was an acute injury, not a spontaneous rupture. And then we have testimony of how he says he slipped and hit his toe and fell. Like, I don't even understand your argument here with respect to the causation.
Your Honor, the importance of that contrary testimony is not simply to argue, as we have, that there be one reasonable inference. It is because it raises the specter now of multiple explanations for what happened. And once that happens...
Right, there's testimony that is, A, there's testimony that that's not what happened, and B, we're on summary judgment.
And there is no reasonable degree of certainty medical testimony that has been given by the plaintiff. They did not hire an expert.
To
They're
do
treating-
what is it that you think they needed to say? Like, what are the magic words? You say spontaneous rupture. All right, assume for a minute, at least for present purposes, that argument woefully fails, because there is evidence in the record that that is not the manner in which it occurred. All right, so we take that off the table. There is some evidence that, like, it happens when your toe and your knee go in tension, right? Which is what the plaintiff testified to. What more do you think the expert needed to say? Like, what are the magic words?
The plaintiff needed to put forth expert testimony, either from a retained expert, which they did not provide, or a treating physician, that to a reasonable degree of medical certainty, more likely than not.
The plaintiff is not obliged to put on expert testimony in order to prevail. I mean, he doesn't have to put on expert testimony. He has the option of putting on the expert testimony, but it's up to the, whether it's helpful or not. The district court will obviously have a discretionary call as to whether to permit the expert testimony under Daubert. But the main thing is that the plaintiff is not obliged to put on expert testimony in order to prevail. The other thing I have is, I always go back to the basic concept of to whom does the defendant owe a duty to, and the duty in this case seems to run to the to vulnerable populations. It runs to individuals who may be disabled or suffer from some condition of the sort that the plaintiff did. And it also, I think, runs to elderly patrons of the establishment, because these falls are nothing to fool around with. If an elderly individual falls, it can break a hip or something and go to the hospital and never come out. And given that, the duty runs to these people. You need to take extra precautions in order to assure yourself that that duty has not been breached. And when you think of the fact that a fall may not be a problem with a 25-year-old, but it could be a problem with someone who has a disability, or it could be a problem with someone in their 70s or 80s. And if the duty runs to those people, which it does, you've got to take extra precautions to make sure that that duty is not breached. And those precautions would be just a little signage or some cones or something. But they're vulnerable populations at the end of this road. That's my concern.
I understand the court's concern. I would also say we would submit that medical expert testimony is required when there are multiple explanations for the mechanism of injury. And that's the issue
What
in this
is the
case.
explanation that you think we should consider that is distinct from what happened, what the plaintiff testified to here?
The three doctors are aligned on the question of there having to be some forced extensions against fixed flexion.
Wait, sorry, just please, plain English words. He's walking out of the store and blank happens. What is it that you're contending is an alternative explanation that blank happens?
We contend that he trips, and then that then leads to the patellar pop
But he
sound.
trips, wait,
So
he trips for reasons that are unrelated to the slippery surface. He
Correct.
just coincidentally trips.
But just let me make sure I understand. You agree that if he tripped, that there was sufficient medical testimony that could cause the tendon rupture?
That the trip is the yes.
Okay.
The trip is the
All right. So then tell me why the plaintiff's testimony that he slipped and then effectively tripped by putting his toe into the ground to catch himself is not the movement of a trip, right? So your testimony, your argument is, if it was only a slip, if this was a cartoon slip, it wouldn't have happened. But we know this wasn't a cartoon slip, right? This is a slip that led to jamming his toe into the ground, resulting in a pop, right? And that sounds like a slip that results in a trip, right? Why couldn't a jury conclude that even on your own theory, which for whatever good that is, even on your own theory, you agree there's enough evidence that if you jam your foot into something causing yourself to trip, that would potentially shear it. It seems like that's what the plaintiff testified happened.
That was not argued to the district court by the appellant. They argued that the slip happened and the slip led to the patellar tendon rupture. And there's no support for that medically whatsoever in the joint appendix by any expert who has to then do that.
So your argument is that they forfeited the argument that the plaintiff fell as he described, that they forfeited their plaintiff's testimony.
What their argument was to the district court was
is that the slip, as described by the plaintiff, is what happened. It is a slip, but it's not a cartoon slip. It's a slip that also involves jamming your toe into the pavement to try to catch yourself, resulting in a pop. It's a slip as described by the plaintiff. It's not a slip on Bugs Bunny.
we contend that wasn't raised to the district court,
So
Your
can
Honor.
I, in your remaining time,
But
can
you
I-
agree if it was raised to the district court, that the summary judgment has to be reversed?
It makes it more complicated with the trip component, which is what's described, as well as the skiing accident mechanism.
I
that
don't
took-
see why you think that you, it seems to me you're working from a premise that in order to escape, that in order to get before a jury, that the plaintiff had to have some sort of expert medical testimony. And I'm just not certain that that is really correct. The circumstances seem to me, a lot of this case seems to me to be within the realm of common sense and sort of everyday happenings with which a jury would be familiar, irrespective of medical testimony. Jurors know what this is not we're not talking about a very complicated product or a sophisticated piece of engineering or whatever. We're talking about people going in and out of a store and somebody cleaning a sidewalk or cleaning an area near the entryway. And jurors have that within their everyday experience. And whereas medical testimony might be very helpful, and the district court allowed your medical testimony in, that it still doesn't seem to me that you can come and say, well, because the plaintiff didn't put on medical testimony about this or that alternative explanation, that they are unable to go to trial. I see that there's a sort of an everyday, everyman component to this case which swings free and clear of expert testimony.
Your Honor, my time has expired. I'm happy to answer the court's question.
Please.
I also have a question.
With respect to Your Honor's point, ordinarily slip and fall cases would fall into that bucket. But we're not dealing here with a broken arm or bruising or scratching. We're dealing with a complicated medical condition that now has multiple etiologies due to the patellar tendon rupture. And that tends to be the issue in the case, which is why we believe under Gambrell versus Burleson and under the litany of cases cited in the Lipitor matter that we cite, that expert testimony is required.
All right, so I'd like to ask you about spoliation and specifically whether the district court's explanation for why it denied sanctions was legally correct. So this is on JA 776, and the district court says the record does not support a finding of bad faith or willful misconduct, and that Lewis has not presented evidence that Circle K acted with the intent to destroy evidence or hinder the litigation, citing an unpublished District of Maryland, I think maybe an unpublished decision of ours for that proposition. Is that not directly contrary to both Silvestri and Hodges, both of which I admit say that absent that finding, you can't get the hammer sanctions. You can't enter judgment for the plaintiff, you can't strike the defenses. But I think we've made very clear you do not have to show that to get any sort of spoliation sanction. True or false?
What those cases do say, Silvestri and Hodges, is that there has to be some intentionality, which we
Yes,
submitted.
you clearly intentionally repainted the lines. There's no question that that was on purpose.
It was done by a vendor who was on a schedule, and the schedule unfortunately was not interrupted. And the schedule is that
No, but again, we have made very clear you have to do something on purpose. But it is not the case. The district court said, I'm just reading what the district court said. The district court said you have to show bad faith, willful misconduct, or intention to destroy evidence. And under our case law, you do not have to show those to get any sort of spoliation sanction. True or false?
false because of the intention piece only. The intention piece, I think, is supported by Silvestri and Hodges. It has to be intentional.
But Hodges explains what the intent is. The intent is not to destroy evidence. So Hodges specifically says you don't have to show intent to destroy evidence, right?
Or, yes, or even do the very thing which is being called
But
spoliation.
that's not what the district court said. The district court said no spoliation because you haven't shown bad faith or intent to destroy evidence, and that strikes me as just dead legally wrong.
I think that it's supported still because of the intentional piece and the fact this was on a schedule, which is in the record, that there were many stores going through this schedule.
Thank you.
Thank you, Your Honors.
Try to be brief, obviously, and answer any questions the court has. I did want to just hit two different topics. Going back to Judge Wilkinson, what you talked about, the things that a store could do, signage and things of that sort. We have evidence, and I'm sure the court preached to the choir, that Circle K knew that. They knew that their employee was supposed to have a safety vest on. He did not. They knew that signs were supposed to go out when they did this type of work. It did not. The testimony was very clear that from Circle K's perspective and from their employees' perspective, that Mr. Lewis didn't do anything wrong. So this wasn't a situation where there was some kind of comparative.
Can I ask you, sorry, I think I got that, but can I ask you about the damages versus injury? Judge Heitens raises a good point, that at least in theory, the plaintiff could have damages for injuries other than the tendon. But when I read your briefing below, your opposition to the summary judgment, you don't seem to make that allegation. You seem to make the claim that the only injury that you're alleging or that you're defending summary judgment on is the knee, that you're not seeking damages for, a cut on his butt or his scraped elbow or whatever it might be. Is that right based on the briefing below and sort of seems like based on the briefing here?
I will say, Judge, that the briefing below and here focus on the patellar tendon. I do believe, just in all candor to the court, that the patellar tendon is the main injury that we're seeking.
Right,
below.
but the main injury and the only injury might be different. And
Right.
I think you could read the complaint more broadly, but I read your summary judgment briefing and your Court of Appeals briefing to sort of say that it's not just the main injury, it is the injury that is being sought here.
Right, and that was more. I do think it is I guess the injury, main injury. I can see the point of the court,
I
but
know, but
there
seeing
isn't
the
anything
point-
in the record that has it other than patellar tendon. I
Right.
can
Seeing
tell
the
you that.
point is to say that, you could have made different arguments,
Sure.
right? The point is, what we've got here is that you've made one injury argument, and the causation was about that one injury, and the existence in the complaint at a 12B6 doesn't help you at the Rule 56 stage.
I don't think it. I don't. In all candor, I don't think it does.
Right.
And because but patellar tendon was what was done. It was part of what the summary judgment was. To that, though, I will say very briefly that the evidence. I believe I heard that there was no evidence that a slip could cause a patellar tendon injury. That's not true. Our doctor specifically said that, and I cited to it.
It's
that
a compact.
an unexpected slip can cause a patellar tendon rupture. That's what. Tell
Tell me where is this the compound question where you asked two things? Can it be caused by a slip or something
I think it
else?
was the or, yes.
It's a compound question, and so, like, maybe we want to read that as answering the first part of the question, but he then, the next sentence talks about the ski binding, right, which really is the second part of the question, not the
Very
first
true.
part.
That's true, Judge. And I will, even if you kind of throw that part out, as Judge Wilkinson is saying, South Carolina is very clear that if it's within the lay evidence or common understanding of someone, you don't need expert testimony to tell you that. And so the common understanding of someone who slips and tries to plant and then hears a pop and then they find out that it's an acute patellar tendon injury, that in and of itself we believe would be enough to go in front of a jury.
Do you think, so accept that for maybe just for half a minute?
Yes.
But even in that scenario, would you need evidence that it wasn't like a spontaneous rupture?
I don't believe we would, Your Honor. I don't think we do have to have an expert. However, we do.
No, I know that you do. I'm
Right.
not.
You
I'm
mean
just
just in
saying,
general.
as a general matter, right?
Right.
That there is, the defense puts on evidence that you can have a spontaneous rupture, particularly for someone who's had a rupture previously, and that's not, at least within the lay opinion, be hard for me to like have a great sense of those two
spontaneous,
things.
right.
A spontaneous rupture, what that even like quite means. Now maybe the testimony like excludes that, but do you think you need that testimony on the spontaneous piece, even if you don't need it with respect to the slip versus trip distinction to the extent it exists?
If I'm understanding, and I'm beyond my time.
I think he'll let you answer it.
If I'm understanding your question, do you need expert testimony regarding the spontaneous? I think you do.
Yeah.
Because that is not something I frankly never heard of a spontaneous patellar tendon rupture until I got into this case. And so, yes, I do believe that the spontaneous, just like a spontaneous whatever, would be within the realm of something that an expert would have to come in and say how that could even happen. Thank you, Your Honor. We would ask that you reverse. Thank you.
Jay, do you have anything further? All right, we appreciate both your arguments, and we'll come down and recounsel, and then we'll move right into our next case. Mr. Aspenbach, happy to hear from you.
Good morning. May it please the court. Jackson Erpenbach for petitioner MD Fareed Uddin. This case presents the pure legal question of whether the elements of Mr. Uddin's New Jersey statute of conviction exceed the federal definition of a crime of child abuse in 1996. Over the last 3 decades, New Jersey has chosen to dramatically expand the scope of the statute at issue. As a consequence, at the time of conviction, the statute exceeded the federal definition of a crime of child abuse in 3 independent respects. First, the statute can be violated with private and consensual conduct that does not harm or risk harm to a child. For example, 2 17-year-olds in a lawful sexual relationship would violate the statute if they exchange nude photos of each other and store them onto their smartphone. or a defendant could digitally manipulate an innocuous photo without anyone ever knowing. Second, in 2013, the statute was amended to cover 17-year-olds, which exceeds the contemporaneous definition of a crime of child abuse in 1996. And third, the New Jersey Supreme Court has held that the statute of conviction criminalizes First Amendment protected activity that exceeds the generic federal definition. If any one of these reasons is correct, then the petition for review should be granted.
Could I just make sure I understand your second argument? And specifically, my question is how I reconcile it with some very sweeping language in two published opinions of this court. Is your argument that Esquivel-Quintana, I guess what I read those two decisions to say pretty emphatically is that the holding of Esquivel-Quintana is limited to the specific types of statutes before the court. So is your argument based on Esquivel-Quintana, or is it based on a sort of more general argument? I just want to make sure I understand the distinction.
Yes, and I read this court's recent decisions in Shea the same way, that in our opening brief, we raised two lines of attack. First is that Esquivel-Quintana applies here. It means that a 17-year-old falls outside the generic federal
Which is a very hard position to maintain in light of our two published decisions saying it does not.
Completely agree. And so our second issue, and I think the issue still before this court, is put Esquivel-Quintana to the side as a matter of first principles, applying basic principles of statutory interpretation. What does the term crime of child abuse mean? We think following the same steps this court has used, for example, in Cruz v. Garland, you start with the contemporaneous definition in legal dictionaries. We look at the same additions this court already has, and also look at how states defined the term back in 1996. We think using those same principles of statutory interpretation that this court has used, you reach the result that 17-year-olds were excluded as Congress would have understood the term in 1996. So we completely understand. Shea, if anything, helped to streamline this case significantly on that particular issue, although I'll note, if you believe that Shea completely resolved that second issue, it doesn't affect either a first or a third reasons why there's not a categorical match here, either that could be committed without harm or risk or harm to a child, and our argument based upon the First Amendment. I'd like to turn to our first reason why there's not a categorical match here, which is that the statute criminalizes conduct that does not harm or risk harm to a child. This offense is different than the types of statutes this court considered in Cruz and Shea. Harm as an element to the offense is not required for conviction. And in our briefs, we provide examples that illustrate that mismatch between the statute of conviction and the federal definition of a crime of child abuse. The first example we have is two 17-year-olds who, under New Jersey law and under the law of almost every state.
So the government says the two 17-year-olds hypo isn't exhausted. Would it matter if it was a 17-year-old and an 18-year-old?
The answer to your question is no, it would not matter. We also do think that exhaustion is satisfied. The way that this court has explained the exhaustion requirement within the statute is that you need to raise the general.
We don't transfer the mens rea to the question of age. I mean, all that matters is whether the victim here was or was not under 18 years of age. Our precedents are pretty clear, and I think the precedents of other courts are clear that we do not transfer the mens rea elements over to the third prong of the test, which is the question of whether the petitioner here actually knew that the victim was under 18. It's just the fact that the victim was under 18, not whether the petitioner knew that she was under 18. Don't you agree?
I agree, Your Honor, that under this court's decisions, we're not making a mens rea argument. We've preserved it in our opening brief, but we understand it's foreclosed by your decision in Cruz. But the argument that we are making is, as a fact, what is the age of the victim? And in particular, what is the least culpable conduct that the statute would criminalize? And our argument is that, as a fact, the conduct could involve a 17-year-old, and that falls outside the definition of a crime of child abuse as it would have been understood in 1996. So we fully agree we're not making a mens rea argument here. We've preserved it, but it's not what we're pushing here. Instead, it's about what does that term mean, and what could the victim's age be as a matter of the least culpable conduct covered by the statute.
But don't we hold here with respect to whether there's a risk of harming child victims? you have two things that are sort of against you here. First of all, this is a file sharing program, which distinguishes the case even without the Third Circuit found that even without a file sharing arrangement, that was still the possibility of harm to the child victims in this case. And then when you add to that the fact that this was a child, that this was a file sharing program, how can that help? How can that be anything other than intrinsically harmful to the emotional and psychological and mental health of the child?
There are 2 points, Your Honor, to address the question of the file sharing program. As we've explained in our briefs, there are many common programs that would qualify under the statute, and even storing on your smartphone, for example, could constitute a violation of the statute. Your Honor refers to the Third Circuit Salmoran decision. We have several different reasons why it does not dictate the result here. The first and simplest reason is that it considered a different version of the statute where the victim had to be someone who was 15 years or younger. So not only it involved a different offense than Mr. Uddin was convicted of, but that it defined a child much more narrowly than the current version of the statute does. And as we explained in our briefs, that's legally dispositive because states generally understand that 17-year-olds can consent to a sexual relationship in a way that a 15-year-old cannot. That's one reason why the Salmoran decision doesn't control here. It also is not the basis on which the BIA ordered Mr. Uddin to be removed. It also was decided under the old Chevron deference regime that did a lot of work in the Salmoran decision. We also have reasons why it didn't engage in the type of analysis the categorical approach calls for, because I completely agree. There are many ways that the statute could be violated that would be harmful to children in a way that's easily understood. But the categorical approach requires, and Your Honor, Judge Wilkinson put this very well in the Cruz decision, every version of conduct that would be criminalized by the statute needs to result in harm or risk of harm to a child. So 2 examples, I've already talked about the 2 17-year-olds. Another one is the digital manipulation or morphing of an innocuous photo, which could happen privately. So there's no harm or abuse that occurs at the time the photo is taken when it's digitally manipulated. And importantly, this statute doesn't require that distribution occur.
But I don't see just as a matter of looking at the New Jersey statute, it seems to me so clear that the New Jersey statute, what it's describing here is a crime of child abuse. What else could it be describing? You know, and if the New Jersey statute describes a crime of child abuse under 1227A, that seems to me sufficient. And we, you know, our precedent says pretty clearly what's necessary for a statute to describe a crime of child abuse. And it says, 1, the offender has to knowingly store an item that depicts the sexual exploitation of a child. And that's what the New Jersey statute does. Knowingly storing or maintaining an item depicting the sexual exploitation or abuse of a child. So then you get down to the second element, which is depictions of harm or risk harming a child victim. And that's especially true given the fact that this is a file sharing program. And then you get to the point of, does the statute cover those under 18? And the definition of the New Jersey statute says child means any person under 18 years old. So what I don't understand is it seems to me the New Jersey statute describes a crime of child abuse and that it covers all 3 of these elements. And that seems to me a difficult thing to work around.
There are several points in that question I'd like to address, Your Honor. one that you did raise is what else could this be called? I think it's actually an important question because the INA is a carefully reticulated statute that Congress has set up and has amended virtually every single year in the past 3 decades, and it's kept these definitions the same. There is a basis for removal for an offense related to child pornography. I think even the government agrees that would not apply here. It's also for sexual abuse of a minor. The government tried that argument. It also doesn't apply here. So I think what's happening is the government is trying to shoehorn this statute that's different from the ones this court considered in Cruz and in Shea, and trying to shoehorn it into this broader, vaguer definition for a basis of removal. And it's really not the classic, it doesn't require offensive touching or harm like those other statutes that this court has considered. And importantly, I take Your Honor's point that this is probably a good law. It's great that New Jersey has it in place, but that's different from whether the particular conduct that the statute can criminalize and has been the basis for prosecutions necessarily results in harm or risk of harm to a child, which is the closer question that needs to be answered.
How do you think we ought to, I mean, maybe you say we've answered it in Cruz already, but how are we to evaluate whether there's a risk of harm? I mean, it seems a little odd for us to be doing as an initial matter, right? As opposed to sort of, having some reference to sort of a legislative judgment about the risk of harm. I think I could tell a pretty convincing story that even the hypotheticals that you've put forward include a real risk of harm to a child that is 17 years old. You say that it's no harm at all, but that seems like just like a value judgment where you and I diverge. Help me understand how you think we're supposed to be doing that. You think it's like a great thing, for 17-year-olds to be doing the things that you've described. Some of us might think it's actually not at all, but that seems like an odd place for us to be, where like your values, or at least as a lawyer, your purported values are like different than what I think is harmful to teens. That's an odd place for us to be. Can you help me understand how you think we ought to be doing that?
It's a great question, Judge Richardson, and I fully agree that this should not be a values judgment, subjective call about who thinks what is harmful or not. And I would also say you could very much conclude that the activity we describe in our briefs is unwise, poor decision-making, should not be done, and even should be criminalized, but it's different from saying in every circumstance results in harm. But I think you get at it's...
That it's harmful to the teen, whether they think it's harmful to themselves or not. Right? My daughter might drink a Dr. Pepper, right? That's not good for her. Like, she doesn't think that's harmful to her, but like, I can make the judgment that it is harmful to her. God forbid it be a Diet Coke, right? But, right? But like, I think objectively it is harmful, right? Whether she recognizes it or such, like, it doesn't really answer the question to me.
So I want to really get to the nub of your question,
Yeah.
because I think it's a good one. I first just want to note that part of the slipperiness here is that because there's not an element in the statute that actually requires proof of harm, many other child abuse statutes do, and it makes this question very simple. There's a mismatch there that we think is more the government's problem than our own. But I actually think Judge Wilkinson's decision in Rangel Castaneda provides a bit of a template for how to think about this. In the same way we might think that these types of activities are inherently harmful, but we want to avoid the kind of subjective differences between courts. You can look at how states have defined these types of activities. And in particular, it is also probably a bad idea for 16-year-olds to engage in sexual relationships, but the vast majority of jurisdictions have made the conclusion they at least have the capacity to make that decision for themselves and don't, as a categorical matter, suffer harm resulting from it. And that's the type of analysis Judge Wilkinson did at Rangel Castaneda we think is helpful here, which is to look at how other states
that's
have
fair,
made a
but that's like a
societal
different, they're drawing a distinction, you might say, between the act itself and the memorialization of related images, right? So like, it seems like to me, if I do that move, that seems to cut against you, because lots of states, and not all of them, I get it's a little bit of a mess, but like lots of states make that the image piece unlawful, even if the act piece is not. So that seems to suggest that the image memorialization point is, at least lots of states believe, it causes harm in a way perhaps that the act doesn't.
I see my time has expired.
I'm sure the Judge Wilkinson will let you answer it.
Thank you. So I think you're right that the question of the age of consent to engage in a sexual relationship It's a different question than whether or not you can share nude images of yourself you've taken consensually. I think if anything, there's a greater includes the lesser instinct there. In particular, because
No, but it seems like
engaging-
that's like exactly the opposite of what the states are doing, though, right? Because the states are saying it's okay to engage in the activity, but it's not okay. And this is just looking at states, which is what you suggested. The states seem to draw the line the other way. Not greater includes the lesser, but in fact, the memorialization of this is more harmful than the act itself.
Yeah, and just to bookmark, we think you should look at 1996 as opposed to 2026, when what we're describing was perfectly lawful in New Jersey up through 2013. But I agree with you that this is a type of activity that can have long-lasting consequences the person at the time might not appreciate. That also, I think, is true of engaging in a sexual relationship. That is something that states still permit. I also just want to say, even if you're not buying this argument about 17-year-olds, we have two additional examples, and in particular, I think the government doesn't have a good response to our example about the digital manipulation of a photo, one that was not harmful when it was created, one that is manipulated only in private, and the statute doesn't require
And this argument is that if you digitally manipulated, I don't want to use a teen's photograph and then shared that around, that's causing no harm to the person whose head is on a modified body. That's the argument you're making.
It's not, Your Honor, in particular because the statute is extremely clear that there does not need to be distribution, intent to distribute, or even that the defendant theoretically knows that distribution is possible. It can be entirely private without anyone beyond the person manipulating the photo knowing it exists that can violate the statute.
Congress passed this statute in 8 U.S.C. 1227, and then it has all of these little identifiers after that point, and it said we're a crime of child abuse, and it was describing it. Wasn't the New Jersey statute, this kind of statute, exactly the kind of child abuse that Congress was trying to get at? I mean, it seems to me when you read the New Jersey statute, it almost seems to me that that's a paradigmatic crime of child abuse. Now, you can go into these rather distant hypotheticals about what it might be applied to, but I think Duenas-Alvarez indicates we're not supposed to indulge these flights of imagination. We're supposed to look at the heartland of what the statute does. And the statute, I mean, maybe my views of it are oversimplistic, but Congress decided it wanted a crime of child abuse to be proscribed in the immigration laws, and what Congress wanted is perfectly set out by the New Jersey statute. The degree of congruence between the federal law and the New Jersey statute, the degree of congruence is absolutely remarkable. And you look at the two and you say, yeah, this is what Congress wanted. This result is what Congress wanted. And you have to be, and I give you high marks for creativity on the way to get around this, but there's a congruity and a common sense element right at the core of the whole matter. And the degree, it seems to me that they match right up. I mean, I hypothetically and imaginatively, I can think of something here, there, or yonder that might at some point indicate a difference, but that's hard for me to do.
Thank you, Your Honor. If I could make just 2 points in response, I think a number of things to address there. One is, respectfully, the best way to know what Congress is up to in the statute is to look at the words that it used. And Congress could have said any offense that involves a child, that's removable. It didn't. It set out a number of different grounds of removal, including one that's an offense related to child pornography that we agree doesn't.
Are you telling me that taking pictures of children under the 18 years of 18 pornographic situations and then putting them in a file sharing program which is geared for further distribution, that's not a crime of child abuse? How can that be? I just don't understand.
Your Honor, at least the examples that we've explained in our brief, which I also want to get to your point about the realistic probability of a prosecution here, because I think it's both, the court's test is a little bit different than having to identify an exact case, but we've also identified prosecutions that happen under this statute. But the point is that the offense committed here, not the production of the images, not the manufacturing of the images or the distribution, all of which are different offenses than the one at issue here, that this statute in particular can be violated without harm resulting as a categorical matter or a risk of harm resulting. I want to quickly address the question of the realistic probability that you raised, because I think it's a good one, that courts shouldn't be engaged in fanciful hypotheticals.
All right.
This statute, I'm sorry.
You want to wrap up very, very
I can wrap up just to say in our brief we explained there are prosecutions like this. New Jersey Supreme Court and the legislature have addressed it. Save the remainder for rebuttal. Thank you.
Interesting. You get any?
I do not.
All right. Thank you. Mr. Zaidi?
Good morning, Your Honors, and may it please the Court. Imran Zaidi for the government. This appeal challenges the agency's determinations on both removability and relief. I plan to focus my argument today on removability and rest on the briefing as to relief, subject, of course, to the panel's questions. Now, on removability, the agency here correctly found that petitioner's conviction in New Jersey for knowingly storing child pornography on a file sharing program made available to others is a crime of child abuse for immigration purposes. Now, you start with the court's definition of child abuse, which we've kind of talked about in petitioner's argument, but I think it starts to just help very concretely. There's three elements as the courts have defined them. First is a culpable mental state. Second is an act or omission that causes harm or a reasonable probability of harm to, third, a child. There's really not much dispute here as to the first and the third elements. First, culpable mental state, the statute requires knowingly storing an image. I don't understand petitioner to even dispute that anymore. Third, as to the definition of child, petitioner had raised an argument based on Escobar-Quintana. We understood their reply brief to concede at least the direct application of that. I didn't understand in their opening brief there to have been two separate arguments. After this court's decision in Shea, this argument about the definition of a child being under 16 is no longer available.
Well, I wouldn't say that.
Pardon me, Your Honor?
I wouldn't say that. I said this court has rejected the proposition that the holding of Escobar-Quintana applies in this situation. I don't think they've conceded that. They make to me what sounds like a first principles. At the time this statute was enacted,
Yes.
Child meant 16 or younger.
Yes, Your Honor, but what the court was considering in Shea was whether or not a challenge to that specific, I think it was an inducement of a minor statute, whether that would be overbroad because the conduct did not involve a child that was 18 or under, compared to a definition.
So if we want to talk about things that weren't addressed in the brief, something conspicuously not mentioned in your brief is former 18 U.S.C. 2243A, which as of the time this statute was enacted, applied only to people under the age of 16, correct?
That's right, Your Honor. That's
And
the
why
statute.
did you not say anything about that in your brief?
Your Honor, again, because of this court's decision in Shea, we don't believe that the argument that this statute could cover the crime of child abuse at ground could relate to somebody under 18 is
Well, let's
available
assume
at
that
the
I
Shea.
don't believe that our decisions squarely foreclose the argument they're making. So what is your substantive response to that statute?
Your Honor, the substantive response here is starting with the board's decision in Velazquez-Herrera, which this court has tracked in every one of its child abuse decisions, that the definition of child is under 18 based on the full assortment of state statutes and other, not that statute, not that federal statute.
You know, a federal statute that defines what a child is for federal criminal law purposes.
A minor, Your Honor.
A minor,
If I'm remembering that statute from Escobar-Quintana
I think you're right.
correctly. And it's not just minor. I believe it was a very similar statute to the sexual abuse of a minor immigration ground. I believe it is a sexual abuse of a minor or ward, something along those lines.
I believe
in
it's a
federal
ward
law.
statute, yes.
Right? So it's an incredibly similar statute to the one that was being considered in Escobar-Quintana. And that's why the court in Escobar-Quintana has at all points limited its holding to specifically the context.
Oh, no, I agree. Every single time the court states it's holding in Escobar-Quintana, it says, we're only talking about this,
Correct.
this statute. But you sort of read it broader of saying, not only are we only talking about that statute, which is what I read the court just making very clear what the precise nature of its holding is, but you read a very large negative implication into that holding, which is, and the answer is thus not the same in any other situation, which I think is an overread of that decision.
Well, Your Honor, it's not our read of it, it's our read of Shea, which is that the argument there was that based on Escobar-Quintana, you must also define child abuse to be under 16.
Right, and I agree. This court has held that Escobar-Quintana does not require us to do that. I agree completely.
Right. But we read Shea at the end to say that it is not a match there. We read Shea to say that the crime of child abuse is defined, and this is what we've said in our brief here, to be under 18. And so I recognize that even at its most, if Shea was just rejecting a direct application of Escobar-Quintana and that there's some other reasoning left over, we don't think that there's anything left over.
Their opening brief is a whole series of arguments. I guess I just keep hearing you say that we've already decided this, and at least and you're not going to concede anything by answering my question.
Sure.
Assuming for the sake of argument that we have not already decided this question, what is your actual response to their argument that all the authorities they cite suggest that at the time in 1996 it was 16 or younger?
Your Honor, it would again be, and because we didn't brief this because we don't think that it is available after Shea, the arguments would be based on exactly what the board in matter of Velazquez-Herrera relied on, which was a series of statutes, many of them, I believe, civil.
A board decision that we don't give any Chevron deference whatsoever to at this point?
Without question, Your Honor, but this isn't a matter of Chevron deference. What this court has already done, even before Loper-Bright was decided, this court had commonly followed the board's definition, but without doing it under deference. So in the Cruz decision, for instance, the court recited the entire, I believe, matter of Velazquez-Herrera decision and then said, we have a very similar definition here. And so the board's reasoning in matter of Velazquez-Herrera, which did examine contemporaneous 1996 both definitions, statutory context, all of the things you would do in a traditional tools of construction analysis, reached that. And I hope that answers your question as to what the affirmative argument would be if Escobar-Quintana was not foreclosed.
Yep, thank you.
This New Jersey statute describes child abuse. It could not be talking about anything else. It is not talking about doing the child a favor. You don't do a child a favor when you photograph them in a very compromising position, and the child is by definition under 18 years old, and you put them in a file-sharing situation. That is child abuse.
Your Honor, you're not going to get any disagreement from me there. I think what I would like to do with that suggestion is put it concretely to an analysis of the elements of the statute of conviction to the definition of crime of child abuse. So we've already taken culpable mental state off the table and the definition of child. Right now, the way we understand petitioner's argument, the sort of meat of their challenge, to be about harm. Whether or not this statute, the sort of outer stretches of the statute.
I worry about Congress. You know, they had a certain practicality in those folks that are good enough to represent us in Congress, and you know, I don't want to leave them scratching their heads. And if you have an appellate court that says somehow that this New Jersey statute really doesn't mean what it says and that it's dealing with something other than child abuse, the good folks on Capitol Hill are going to be saying, what? They're going to be scratching their heads.
Judge Wilkinson, I agree with you fully, and I want to be clear that in addition to what you're saying, which is just as a matter of common sense and practicality, we're right, I want this panel to understand that as a matter of elements to elements.
I was going to say, because the categorical approach has repeatedly said we don't do practicality and heartland.
I want to be very clear, Your Honor, because we grounded, of course, our analysis in the categorical approach and the elements. So on the second element of the court's definition, which is an act or omission that causes harm or a reasonable probability of harm to a child. Petitioner's argument is that this statute sort of pulls in conduct that falls outside of that definition.
Can I just give you a hypo that illustrates to me why this seems so strange to me?
Sure.
So we all agree that the age of consent to sexual intercourse in New Jersey is what?
Under 18.
Okay. So imagine two high school seniors. Mm-hmm. One is 17 years and 364 days old. One is 18 years and 1 day old. The two of them have sex, which is perfectly legal in New Jersey. Sure. It is perfectly legal under federal law. It is perfectly legal in New Jersey. And as a matter of sort of some Gen Z desire to document every single moment of their entire lives, they snap a picture, and one of them has a cell phone that connects to Google Photos or Google Drive, which I suspect lots of people's cell phones connect to Google Photos or Google Drive. Mm-hmm. It just feels weird to me to say that the sex is, and oh, by the way, this is not like, this is just literally two teenagers who had sex taking a picture of both of themselves.
Sure.
And uploading it to Google Photos. And so the sex is perfectly legal, but the fact that they snapped a picture on a phone that's connected to Google Drive is now a crime.
So, Your Honor, I appreciate that you have done the work of using a file sharing program and not just saying an Apple phone and that might be a computer and there's nothing else.
No, Google
I
Photos.
would-
He's not doing that. He's actually doing the opposite of what you're suggesting he's doing. He's saying it's Google Drive. So it's not a file sharing program, it's your own Google Drive, which is accessible from both
Sure.
your phone and your computer, but it's not a file sharing program he's giving you. He's giving you iCloud as the same,
Right.
would be the same
I'm
example.
sorry, who's the he? Judge?
Me.
Judge
Right.
Heitens.
Because petitioner mentioned cloud, and I can't remember if there was a
This
Google
is a
Drive, but
cloud
yes.
question. His
Right.
question is both two consensual teens. That's one part of it that he's
Sure.
hypothetical. And the second part is that it's a cloud.
Sure.
Right? It's not a sharing program, it's your own cloud, but is
Right.
accessible from maybe more than one computer.
Sure. And so the starting point is, how does that match up with the definitions and the elements of this
Can I
particular
just-
offense?
As a matter of Google Drive, I can make my Google Drive available to other people, right?
I believe so. Yes.
And Google
I believe
Photos.
that's what a Google Drive does.
Right.
Right? That's what you can do.
So that's a file sharing program under the statute.
Yes. I believe so as a general proposition. I do not know that that is true for the purposes of this statute.
I'm just looking at the definition of file sharing
Just looking
program
at the
under the
definition,
statute.
which seems to be very,
It is a
And this-
computer
it's a
program or
computer-based
application
program.
or software, which Drive and Photos both are, that allows the user of a computer, which my iPhone is, on which such program, application, or software is installed, which it is, as available for searching or copying by one or more other computers, such as my laptop, my iPad, my spouse's laptop, my spouse's iPad, any number of other people's, all of which are computers. Right?
and
Why
to
isn't that a
make
file
those,
sharing
and
program?
then to make them through this definition, through the statute.
That's why people put things on Google
to
Photos and Google.
designate those files
Right,
as
to
searchable.
designate, not even that I have
Correct.
to do it. It's that I can designate, I will represent to you that I can designate my Google Photos to be shareable by anyone I want.
Right. And so the question is, under the different definitions you need to satisfy under the statute, is one, it needs to be an image that is depicting the exploitation or abuse of a child, and then second, to satisfy that file sharing program definition, which is to be placed on a program that shares files with others and to be made available for searching and copying. Now, you understand those two elements also in the context of what New Jersey Supreme Court has said about this statute.
About a different version of this statute, you mean?
A different version with different classifications, and has said that this exact classification that's at issue in this case, which is the file sharing version of it, is tantamount to, on the same level, second degree, as the distribution offense. So Sisler, yes, was 10 years before this subsection was added. And what Sisler said is the statute has meticulously denominated the offense levels and severities of conduct, and then 10 years later, when the legislature added this statute, it said this will also be classified as a second-degree offense like distribution, which means it is sentenciable for 5 to 10 years. Petitioner here was sentenced to 6 years in prison because of the severity of that offense, and that possession is less than, but we still think would be crime of child abuse material, but is less than storing it on a file-sharing program or the distribution of those materials. If the court has any pause about any of what I just said, we are talking about we are actually literally talking about hypotheticals. So what do you do with hypotheticals or more attenuated theoretical assertions of what a statute might reach? You need under Duenas-Alvarez to satisfy that with
Well,
the
can you
realistic
answer my
probability
hypothetical
test.
about whether you think that violates this statute, and if not, why it doesn't?
I don't believe that it falls under the statute, Your Honor, for the two reasons I just said, which is the images that must be covered under the statute must themselves be exploitative or abusive to a child. And I don't think that that is a file sharing program. That's certainly not how New Jersey has understood a file sharing program, to just be placed on a Google Drive. We would say that that is at a minimum something theoretical enough that you would need to show a case example and satisfy it under the realistic probability test. And I would understand your example, by the way. This is a bit semantics, but it matters here. You're talking about the 18 and the 17-year-old, right? Not
Sure,
what
I
the
understand.
full-
I was deliberately trying to avoid your
Right.
argument that the 17-year-olds are not
the
exhausted.
juvenile proceedings. Yes, so to that would be the argument there. And again, understanding those elements, the way that New Jersey and Sisler, which does apply here in terms of how it's decided the statute, how it is understood the statute and the offense levels. So the other examples the petitioner has raised here, I'm sorry, Your Honor, there's some other realistic probability test. Petitioner never really, I think they started to in the end of the argument get to that. We still don't understand any of petitioner's arguments about realistic probability to have even tried to raise an example of a crime that reaches this conduct, one, just on the substance of it, and that is done so that led to a conviction, which is what the realistic probability requires as interpreted by this court in Battle. And that's for good reason. You do that because you want to make sure that you know a state statute is not just even charged, but it results in a conviction that the state has actually applied a statute in the manner in which, the non-generic manner in which the petitioner has asserted. The other, so I think I've addressed the sort of sexting examples between teenagers. I think that's the primary basis for petitioner's challenge. There's a few other ones based on this after the fact manipulation.
Can I ask you about their third argument? I'll just say as a matter of intuitive sense, you're sort of, he couldn't have been charged under that version of the statute because that version of the statute couldn't have applied to him because it would have violated the ex post facto clause to apply that version of the statute. But I look at our cases and they say over and over and over again, it is the offense as of the time of conviction, not the offense as of the time of conviction led in light of the restrictions that the ex post facto. You know what I'm saying? Like none of our cases have this carve out. That's a pretty novel argument.
There's no question. I think, to be clear, you're talking about the pulling in the unconstitutional conduct argument.
Correct. And you say it's no big deal because that version of the statute, even though it had been enacted at the time of his conviction, couldn't have applied to him consistent with the ex post facto clause.
That's right.
And that might be right or wrong. I guess I'd have to figure out what to do with all of the times this court has said the offense at the time of conviction.
No, it's an interesting and very important question, Your Honor, because you're 100% right. There is not much case law out there on this, and that's for the very simple reason.
There's not much, or there's none?
There's Marrero, which at least actually goes through the exact analysis you would need to follow. But the reason that there isn't much analysis or holdings on this from any court, not just this one, is because very commonly, and I honestly will put a number as high as somewhere in the 90% range, you have a date of commission and a conviction date of conviction addressed under the same statutory ground. Nothing's changed between those two times. That's just the practical reality. Sometimes it will be the case that the statute is materially changed between the time that somebody committed a crime and that somebody was convicted of that crime. And in that, it's just black letter law that you are convicted. You cannot be convicted for something that was not criminal at the time that you committed the offense. That's ex post facto law, both under New Jersey and under federal law. And because the categorical approach, it's not as frustrating and as constraining as it is asking a simple question, which is, what do we necessarily know you were convicted of? And because of the ex post facto clause, we know you were necessarily convicted only of conduct that was criminal at the time that you committed it.
How do I know that?
This categorical approach, I'm not sure it requires an absolutely perfect match. And the Supreme Court has, when the categorical approach first came in, the whole concept of least culpable conduct was applied by imagining this and that, and to which the statute could be applied. And then I think the Supreme Court found that that was resulting in some rather odd situations and atypical situations. And it backed away from the idea of a perfect match. And then you get what was a seminal decision in Duenas-Alvarez, which said we are not to imagine things like sexting between teenagers or consent, none of which, of course, is involved here at all. And said, oh, you can't look at the facts. And you don't need to examine all the facts, but the point is that the Supreme Court has begun to loosen a little bit the strictures of the categorical approach and to demand something, to require something less than a perfect match, and to look at the gravamen of the New Jersey statute and the center of gravity of the New Jersey Supreme Court decisions and what Congress was trying to get into, and that a certain spirit of practicality and common sense could be applied to the problem. And that's sort of where we are.
Your Honor, I think the one thing I would clarify there is I do think the Supreme Court has made clear that you cannot make arguments based on sort of hypothetical conduct, but they're still doing it within the confines of matching the elements of a statute of conviction to the elements of a federal or generic offense. So I certainly agree that there are times when somebody asserts that a statute is overbroad in a way that's may be technically possible, but that is imaginative and hypothetical. And for those, the Supreme Court, you are absolutely correct, has clarified you need to substantiate those with actual case examples, and you need to show a conviction, especially as this court has confirmed. The one other example that we didn't get to is petitioner's hypothetical. I just want to touch on this really quickly. The example of sort of the morphed or manipulated image. So take a picture of a child from his 14th birthday party, and then you, through the computer, take off their clothes or depict them in some sexualized position and share it with other people. Honestly, Your Honors, I struggle to understand why this action isn't even worse than what's at issue in the subsection here, because then you yourself are the one who is sexualizing and abusing the child through your action of morphing their image and then sharing it with other people. But I think the point is, once you have satisfied the two actual main elements of this statute, which are you have depicted a child in a sexually exploitative or abusive way and then placed it on a file sharing program that is searchable or copyable to others, you have committed a crime of child abuse. And I really don't think there's any question about that. If there are no further questions, Your Honor, I ask you to deny the petition. Thank you.
You okay? Oh, you had your-
I'm good.
All right, Mr. Erpenbach. We'd be glad to hear from you in rebuttal, sir.
Thank you, Your Honor. A few quick points in rebuttal. I'd like to focus on some of the arguments I didn't get to address as fully in my opening statement. I want to start with our second argument about the definition of a child does not include a 17-year-old as defined in 1996. This is, at bottom, a standard statutory interpretation case, which used the standard tools of statutory interpretation. Looked at the meaning in authoritative dictionaries, like Black's Law Dictionary, any others that this court has used in the past, and look at a survey of the states. Both of those basic indications, which this court has previously used to define a crime of child abuse, point in the same direction, just that Congress would not have understood 17-year-olds to be included within a crime of child abuse in 1996. Judge Hyten's asked about 18 U.S.C. 2243. I understood the government's argument to be that it doesn't apply effectively because it uses the word minor instead of child. We're happy with that distinction because, as Black's Law Dictionary substantiates, child is a narrower term than minor, and it's also reflected in the state laws.
As in minor is someone who just lacks legal capacity?
That's our
Or is too young to have legal capacity?
Yes, that's our understanding, and then the common law understanding that the established meaning in 1996 was younger than that. And the government also raised the BIA's decision in Velasquez-Herrera in 2008. Even if we had Chevron deference, it's not exactly an opinion that deserves deference from this court. That court had two reasonings for why 17-year-olds can count as a crime of child abuse. The first is that, well, we said it already for sexual abuse of a minor, ergo it must be the same result. And then a footnote in which it said that 48 states and DC all define it that way. I think we've proven pretty definitively in our briefing that that is not the case based upon a survey of crimes of child abuse in 1996. And I would also point this court to the 10th Circuit's decision in Ibarra v. Holder that we cite for why it's important to look at criminal statutes, not just any civil statute. One notable demonstration of this is Missouri's laws, which the BIA points to as a good exemplar for their definition. In 1996, Missouri very clearly defined a child to not include someone who is 17 years old, and it even made the distinction between minors, which is anyone under 18, and then a child, which I believe was 16 and under. And there was a criminal statute in place that made that clear. We survey a number of others in our briefing. Also, very clear examples are this very statute at issue here, which is New Jersey's primary child endangerment statute, and the A provision that's not at issue. That was not defined to include a 17-year-old. New York statute is the same. Iowa's, I could keep going. The government doesn't have any substantive response to that. Again, put Escobar-Quintana to the side. Approach this as a basic statutory interpretation question. You might think Congress today would reach a different conclusion. It's ultimately for Congress to make that decision. They've amended the statute many times. They've never seen fit to provide any definition or to change this. And so this court should apply this as a statutory interpretation case. The next point I'd like to address is the scope of the statute, which received a lot of back and forth with the government's argument. The question about whether Google Drive or Dropbox or any number of other programs you're familiar with, Apple iCloud, are covered, is answered by a New Jersey Appellate Division case that we cite in our brief on page 4, which involved a conviction for storing the images on Google Drive or Dropbox. I understand the concern about engaging in hypotheticals or dreaming up scenarios. This is activity that teenagers unfortunately do engage in on a regular basis, and we've identified prosecutions that do closely map to the examples we raise in our briefs. And if you have further hesitation there, importantly, it's not about whether a particular prosecutor will choose to convict for a particular crime. It's about what the statute says. And in the government's back and forth, they don't raise a reason why the statute is ambiguous about the conduct that it covers. And this court's decision, Gordon v. Barr, makes clear that if the statute is clear, that answers the question. We also have a decision from the New Jersey Supreme Court that answers the same question, language from the New Jersey legislature. I also want to quickly touch on our argument about the First Amendment. I think Judge Heitens raises a good point that it would require changing this court's approach to the categorical approach and throwing out any number of standards that this court, other circuits, even the Supreme Court has laid out.
But could you respond to
Oh, sorry.
No, go ahead.
We're going to say the same thing. Go ahead.
Could you respond to the government's argument that fine, but yes, those cases have never addressed this question, and if the whole point of the categorical approach is to ask, quote, what crime the defendant was convicted for, obviously the defendant wasn't convicted of a crime that would violate the Constitution to have convicted him of that crime.
So I don't understand the government to be saying that the ex post facto protection would be violated here, but that it could be in a future circumstance. Say if instead of this statute getting broader and broader, it got narrower such that there's no longer a categorical match. Our understanding is that it's never arisen in a case except for Marrero. And Marrero, which was an unpublished decision, actually raises the concern with applying that kind of test, which is that there would be inequities between defendants. So in Marrero, the Shepard documents did not say when the conduct occurred. In New Jersey, we have documents that do say when the conduct occurred. So identical conduct, I'm sorry, my time has expired.
You can answer this.
Identical conduct on different sides of the Hudson then receive very different consequences under the immigration system, which is exactly the kind of unfair inequity that the Supreme Court has said the categorical approach is designed to avoid. I also want to just quickly touch on our discretionary cancellation of removal argument, just to say we're maintaining it. I would point this court to the decision of Cortez v. Garland, which is binding. If anything, I think the legal errors here are simpler, more
Thank you.
straightforward.
Thank you very much. Hold on a minute. Do you have anything further?
Thank you.
I see that you're court appointed, Mr. Erpenbach, and I really want to thank you on behalf of the court. You've obviously put a good deal of time into the preparation and presentation of your case, and we really are most appreciative.
Thank you, Your Honor.
We will adjourn court and come down and greet counsel.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.